Yeah.
If this is 1 and that was 7 and I had 5,
Yeah.
right? So not sure which one to do with. Compared to this species, I'm on the base side.
Right.
So it's the base one.
Okay.
Compared to this pair, I'm on the acid side. 5 is more acid than that number there. So it'd be the acid one. It turns out
Oh, so okay.
it's the same thing.
Oh, right. Okay.
So in other words, less than this number, I've got H3PO4. Between this number and that number, I've got H2. And then I swatch to H, and then I swap to PO4 for minus.
Right. Okay.
But just anchor yourself on if the pH is equal to the pKa, I have equal amounts of those two. Right? And then decide where am I at pH equals pKa, or am I on the acid side of it, in which case I have more acid, or am I on the base side of it, in which case I have more base. And if you're unsure, just choose the closest pKa.
Okay, thank you so much.
No problem.
Good afternoon, everyone. We'll get underway. For those of you still arriving, just grab a seat. I'm just going to recap where we were last week in the very exciting topic of theft. Thank you all for coming this afternoon for the rest of this scintillating topic. I'll do my best. I know it's a nice afternoon, so I'm grateful for your presence. So you'll remember that last week we were covering Section 219, looking at theft. We had got through all the actus reus requirements and were working our way through the mens rea. We had got through dishonestly and without claim of right, which I'll just do a quick recap on, and then we'll cover with intention to deprive permanently before moving on to our other offences. So a quick recap. Dishonestly is where you do something without a belief that you have express or implied consent or authority to do that thing. And you'll remember, for those of you who were in the workshops, that consent or that authority is now a legal authority. Okay, so it's not fraudulently as it used to be, where we were thinking more about whether or not the person had behaved in a morally dishonest way. Now it's whether or not the person has behaved or done the act knowing that they did not, in fact, have legal authorisation or consent. Okay, so we've tightened up the law in that regard. And when looking at the case of Fairley, where they, under the old law of fraudulently, where he had taken the 40p out of the till, and they said, well, obviously that wasn't fraudulent, would be inappropriate to attach any moral obloquy to that. Nowadays, we would say that that was dishonest because he knew when he took it that he did not, in fact, have consent. So even if you know that if you asked that you would get it, but you know that at the time that you do the act you don't have it, you will have acted dishonestly. Claim of right, used to be called colour of right, is where you act without a belief that you have some kind of legal, proprietary or possessory interest in the property. And again, we've tightened the law up on this. It used to be that provided you had a belief that what you were doing was lawful, genuine belief that what you were doing was lawful was enough. Now it relates more to the rights of possession or rights of ownership in the property. And we've, as you will remember, we referred to the Leeson case, which you may recall from defences, where these guys went in and punctured the dome, causing millions of dollars worth of damage, and they claimed that they thought they had a legal right to do what they did, and under the old law, colour of right sufficed. Under the new law, because it now relates to a right to possession or a right to ownership, it wouldn't. Case of Burton Police, 2012 case, made it very clear as to what claim of right means, and also made it clear that it must relate to the property itself, to which the offence relates, and if you have a genuine belief, even though it's unreasonable, that will suffice to show that you have claim of right, but obviously the more unreasonable your belief is, the less likely you are to be believed. Right? Remember, these are subjective beliefs, subjective mens rea states. in the case of police in Minhinnock, now this was under the old law. This was a case where the defendant was from Ngāti Nui. He was a descendant of that iwi, and one of his descendants had been killed when the land was confiscated, and he went and saw a rare medal in a museum which had been awarded to the British officer who had been involved in those wars. And he claimed that he felt his ancestors telling him to bring the medal and bury it with them on the mountainside where the battles occurred, so that they could forgive the people who had carried those actions out and had taken their land. And he described as evidence an overwhelming emotion when he looked at this medal, which made him take it. But not only did it make him take it, it gave him the right to take it. Now, the magistrate was incredibly impressed by his evidence and held that he had a colour of right. So this was obviously under the old law. Obviously, under the new law now, he would have to show that he had some kind of right to possession or proprietary right, and that would not suffice. It would raise issues as to whether or not he could claim some kind of tikanga Māori customary right, but under the new law, that hasn't been tested. If anyone's interested, there's an Australian case as well, where this guy got himself into a bit of strife, purchased a bow and arrow, got into a bit of money strife and tried to return it. They wouldn't take it back, and so he went and bought a gun, and he went in and tried to get his money. And he alleged that he had claim of right. Now, he was charged with robbery because he was basically committing, in fact, he was charged with aggravated robbery, I think, and he was, in the end, he was not convicted of that offence because the court said that he had a claim of right in relation to the demanding of the money, and that knocked out that portion of the offence. Okay, so claim of right can become, not just in relation to theft, it can become a really important part of an offence if you can show claim of right to knock out quite serious offences. Final mens rea element for theft is looking at an intention to permanently deprive. Now, this has got two aspects to it. It includes the intention to deal with the property in such a manner that it can't be returned in the same condition, or that you are likely to permanently deprive the person of it or any interest in it. Okay, so if you deal with it in such a way that it can't go back to the person in the same condition, then even if you were not intending to hold on to it, then you will still have been intended to have permanently deprived the owner. So it's much broader than it used to be, and it can sometimes come down to a question of what is the meaning of the same condition. Where is the line as to what is the same condition? What about minor wear and tear? And where is the line there? You remember the Zabritsky case where she allowed her child to play with the pram and they said it couldn't be returned in the same condition, and therefore it was an intention to permanently deprive. So the courts have said it's broad enough to cover general wear and tear, and will definitely cover a situation where there's damage or the item's likely to be destroyed or lost. Now, there was an interesting case, and this is in your readings, this is Moranga, where a guy was bar manager, and he was supposed to remove and bank the profits from the gaming machines in the bar. But on this occasion, he took some coins from those machines and he sat there and he just kept feeding them into the machines. Now, every time he won, he put those coins back into the machines. Right, so he ended up, he took home around $9,000 and he pleaded guilty to the theft of that amount. But it was whether or not the money that he kept feeding into the machine was also theft. And when they actually did a subsequent audit on the gaming machines, the shortfall as a result of what he had done amounted to about $34,600. Okay, so it wasn't a small amount. And the court held that he couldn't be guilty of permanently depriving, so he couldn't be guilty of theft, because he was recycling back into the machines the coins. So he was basically returning the same coins back to the owner. All right, so there was no intention to permanently deprive. So this was not a case of forced substitution, where he had taken the money and intended to pay it back, so taken it without consent, and therefore didn't take ownership, and intended to pay it back, thereby forcing a substitution. He was returning the exact same money back into the machines. Okay, and they said that that wasn't theft under Section 219. So that raised some interesting questions about how the law operates. Right, so there was no forced substitution in that case. So that's about as much as I want to say about theft, other than I suggest, for those of you that didn't attend the workshop last week, that it would be worthwhile listening to the recording, just because it will help you to work your way through some of the scenarios, or at least go to the tutorials in the next week or two. Right, turning now to theft in a special relationship. Now, this is one that you will see plugs some of the gaps in relation to theft. Okay, so this deals with a situation where particularly you might have become an owner of property as a result of someone giving it to you for some purpose, and then you use it in a way that is different to the terms upon which it was given to you. Okay, so you might even have become the owner of it. And so in the case of money, ordinarily we would have said it's not theft because, of course, as an owner you can do with it what you like, but this plugs that gap. Okay? So theft in a special relationship is what we call it under Section 220, and looking at subsection 1. This is setting out essentially the requirements, so where a person has received or is in possession or in control of something, some property, and it's on terms or circumstances where they know that they had to account to some other person for the property or any proceeds from that property, and they must then deal with the property in accordance with those requirements. Okay, so it's just setting out the basics of the requirement of the offence, that if you receive it on terms, you must deal with it on those terms. So the offence itself then is about if the person then who's required to deal with property on those terms intentionally deals with the property or any proceeds otherwise in accordance with those requirements. Okay, so it's quite a simple offence really in many ways. And the offence applies even if you intend to deliver over the property or identical property to the property received. Okay, so the whole essence of the offence is that you've done something different than you were required to do. So when we look at our actus reus requirements, what has to be proven by the prosecution is that the defendant received or had possession or control over property. And you'll remember that, of course, property is defined extremely widely in Section 2 to recover all sorts of things, tangible and intangible. You then have to show that the terms on which the defendant received or obtained possession or control required them to account or deal with it or the proceeds of it in accordance with those requirements, so on terms. Okay, so it's earmarked with some kind of term or requirement, and that they did something different to what they were required to do. Okay, they varied from the requirements. So essentially the whole idea, or the essence of it, is that when you receive the proceeds or you receive the property, it's earmarked for you to do something with it, and you do something different. In terms of the mens rea requirements, the person has to know about the terms attached or the earmarking. Okay, you can't be required to comply with it if you don't know about it. And then they must intend to actually deal with the property in a different way. So hopefully you can see it's a much simpler section than theft itself, which seems bizarre in many ways, but helpful for your purposes. So it can cover situations that theft doesn't cover. So particularly around fungibles, as I said, around money, where you receive money, which of course being a fungible means that you've got ownership. And if you have it on terms to do something with it, and you've done something different, then this is where Section 220 will come in, where 219 didn't. It will also cover a situation where the person actually didn't ever receive possession or ownership over the property, but had some kind of control over it. Now, for those of you that have got business brains, you might be starting to see that this is the section that is very often used to cover situations where finance companies have used money not in accordance with the terms upon which they receive it, okay, which was a huge problem, particularly in the late 80s, when a whole lot of finance companies went bust. And how could they then try and charge the people who were responsible for that when they had not done with the money what they were supposed to do? You'll also often see it happen where you've got an employee and employer situation, when an employee might be going around collecting money or receiving money, or where you've got someone who's perhaps collecting rent, or collecting commissions, right, or raffle money. So when you go around selling raffle tickets and things like that for sports organisations, you are collecting that money, okay, with terms attached to it to hold on to it and account for it and give it to the organisation you are collecting for. And if you do something different to that, then you are guilty of theft in a special relationship. It also covers situations where you are a solicitor, so you've got a fiduciary relationship, and you've got money coming into your trust account. Okay, again, that was a big problem, which I think when that went back to maybe the 80s, early 90s, where there were a lot of solicitors that were getting into conveyancing, and getting large amounts of money being put into their trust account and then using it for purposes other than what they were supposed to. And it led to large amounts of money from a few firms going bust or using that money and then not replacing it. So it got found out, and lots of people lost large amounts of money. And it resulted in every firm in New Zealand, every solicitor's firm having to contribute an amount of money into a fund to ensure that if that ever happened again, there would be money to pay people out. Right? So it's can cause problems, obviously. Now, you've got to have actual control of the money. Right? So if you receive the money on terms, you've actually got to be the person who has some kind of actual control over it. So that's what really counts, is who has the control. And the courts have been very careful in looking behind sometimes company structures to see not necessarily what the structure of the company is, but actually who had the actual control over the money itself or control over the property. For those of you that aren't familiar with companies, and even if you're not going to get into commercial law, I encourage you to at least do company law while you're here at law school. Having an understanding of a company is really important, irrespective of the kind of law that you go into. Right? So a company is a separate entity in and of itself. Right? It is, even though it's obviously not a person, it's not anything that you can sort of hold up and go, this is a company. It is a separate entity. So if you are a director of a company or a shareholder of a company, if that company goes bust, right, unless you as a director have done something in breach of your duties, then if the company goes bust, then you are protected. Okay, you don't lose your house. Okay, it's the company that goes into liquidation and not the people behind it, which is why all these finance companies was a problem. So your company will have directors, depending on the size of it. You'll always have directors and shareholders, but sometimes you'll have managers. Obviously, you'll have employees. Sometimes you'll have directors who are employees, etc. And it will depend on the size of the company as to how much your directors have control over property, but they don't actually own the property. It is the company itself that owns the property. So you can see that there are problems that arise when directors start using the property as if it's their own, as opposed to company property. And what happens is when this happens is we do what we call piercing the corporate veil. So we go behind the sort of shelter of the company to try and get to the directors behind it. Okay, so that when they use the company to protect themselves, we call it piercing the corporate veil to get to the directors behind the company. And this is one of the problems that arose in terms of white-collar crime. So this is what the Serious Fraud Office was set up to do, and this is where Section 220 has really come into its own. So when Queen and Sullivan were looking at who was actually in control, sorry, I know that was a little long-winded, but for those of you that don't know anything about companies, you need to know that to have an understanding of how these cases work. And Queen and Sullivan, when they were looking to see who was actually in control of the money, they were looking at a whole lot of finance companies that had collapsed and how were they going to prosecute the directors. Now, the directors were required to deal with the company's property responsibly in accordance with the terms of the prospectus. So they took money from, obviously, ordinary members of the public who had invested in the company, and that money then became into the company on terms, but of course is not owned by the company. The directors don't own the property itself, and the property is earmarked provided there are sufficient certainty of terms. And what the court looked at was control and reality. And they said often the fact that an accused is a director of a company will lead to an inference that the ability to control application of the funds is exhibited. But the mere fact that someone holds office as director does not mean that control has been proved. A more sophisticated analysis is required, and you have to look at how the company is really being managed, not just the formal legal arrangements. Conversely, it is possible for a non-director to have control over the use of the funds. So sometimes they said it can be a de facto or a shadow director who actually had control. Right, so they were really looking at what was the true chain of command and the reality of things. Okay, so it's the actual control over the property, not the perceived control. In terms of a requirement to account, this is a question of law, not a question of fact, right? So this is something that the judge must determine. And what is an obligation to account is a little bit vague, but in a general sense, what they are looking for is an earmarking. Right? And where problems arise is whether or not you're looking at a simple debt situation or whether or not property was provided on terms sufficient to earmark the property. Okay? And that can become a very difficult fine line to navigate depending on your documentation. So you're having to look at whether or not you've got more than a mere obligation to repay, which would be a civil debt, and an earmarking of the property. In scale, now this was a weird situation where a company's computer kind of lost the plot and started sending out cheques willy-nilly. And it sent the defendant in scale a cheque, which he banked. He was in a little bit of financial strife, and he used the money. And the court had to consider, did he actually receive that money on terms to account, or was it simply a debt situation? And the court said, no, he didn't. He just had a debt situation with the company that supplied the cheque because there was no earmarking of the property when he received the cheque. Even though he knew that he wasn't entitled to it, there's no requirement of dishonesty, as you'll see when we look at mens rea. Because it wasn't earmarked, Section 220 didn't apply. In the case of Kirk, now this was a situation where a guy was, he had an arrangement with a draper, sort of draper's a curtain maker, where he received commission. So he'd sell the draper's services to someone and then he'd get a cash deposit. Okay, and then he was required to collect that, pay it to the draper, but he wasn't actually giving the draper the full amount. He was sort of siphoning a little bit off the top. So he was underpaying him, and the question was whether or not he had received the funds on terms. And they said that basically it was a failure to account, and he had received that money earmarked to hold it for the draper, and therefore he was guilty under Section 220. Under prior, this is a slightly different company situation to show you the distinction The company directors realised the company was going under. They were in trouble and they pulled all the available funds out shortly before it went into receivership. And this is not uncommon, this is quite often what happens. And they owed a whole lot of unpaid wages to staff and unpaid tax. Now, this could give rise to civil situation where you try and pull that money back, but they had to consider whether or not there was theft in a special relationship. And the court said not every single time that the company directors handle the money is going to be covered by Section 220. And in this case, it didn't give rise to an obligation to account, even though there was a fiduciary relationship with the company. Okay, so even though the directors had a fiduciary relationship with the company as a separate entity, that didn't earmark the property. Right, so hopefully you're getting the idea that it's the earmarking of the property that is really the important point. I'm going to leave Talentire, but I'll cover Nisbet. So in the case of Nisbet, so this was very much a contextual inquiry. So this was two shareholders in a company, and one of them owned another company, and they received money. They took out a loan to buy a property, and one of them used it for his other company because he'd become liable to pay GST. Right? So he was trying to avoid inland revenue coming after him. And the question was whether or not the property was earmarked. Now, they were looking at the written shareholders agreement, and there was an obligation under the agreement to give effect to all agreements between the two shareholders as to project financing and to unanimously make important decisions. Right, so they held that in those circumstances, the combination of that and the discussions that had been had between the parties meant that he had received the money to use it in a particular way, and he had failed to do that. Okay, so the court will look at all manner of things to decide it. And if you think it's not really that important, many, many years ago, we had a client who was an ex-policeman, and this was exactly the situation we were in trying to prove that money he had received was a debt situation, and we just could not, despite the fact we had numerous documents, get over the line in showing that it wasn't just a debt situation, a civil debt. So he was held to have failed to account for the money he'd received, and he ended up going to prison for 2 years. Now, he was an ex-policeman. As an ex-policeman, that was a frightening situation for him. I remember going and seeing him in the prison, and he said it was the scariest night of his life, the first night that he was in there. Right, so the line is really important, that earmarking is essential. Where it won't apply is when you've got generic obligations. Okay, so Whale makes this distinction between specific obligations and relating to the property and generic obligations. So when you're talking about generic obligations, you might be talking about things like the requirement to carry on a business in a prudent and business-like manner. Okay, so when you put out a prospectus and say we're going to carry on business in a prudent and business-like manner, the money comes in as a result of that, the money is not earmarked. Okay, it's too generic. It's got to be more specific than that. So you've got to recognise that distinction between specific and generic. I'm just going to have a look at that's what I want. In terms of just your mens rea quickly, now You've got to know about the requirements. Now, we've covered knowledge and mens rea. That's pretty clear. Okay, so if you don't know, you can't have satisfied that mens rea requirement. And you've got to intend, so it's got to be your purposeful desire to depart from it. Now, note there's no requirement of dishonesty, and there's no need to prove claim of right or lack of claim of right. Okay, so it really does fill those gaps of section 219. All right. Moving on to our obtaining by deception offences. Now, I'm just going to touch very briefly on 228, mainly because I think it will assist you in seeing the distinction between where one offence starts between 228 and 240. Right, so very briefly on 228, so you can just see just where the line is between 228 and 240 a little bit, and then we'll get on to burglary, which is really quick, but I'm going to spend most of this time on 240, which is your obtaining by deception, which is a much more complex offence. So 228 really covers a situation where you might have, where it's not theft, so you might have a situation which was not theft because the defendant didn't take or deal with the property belonging to someone else. They might have used their own property, or they've committed theft and what they've taken is of little value. Okay, so we might be talking about a piece of plastic. So my credit card is just a piece of plastic. Okay, it has little value. Right, but you can use it in such a way to get something of greater value. Well, you probably can't right now because it's maxed, but potentially you could. Right? So this covers those kinds of situations. And the essence of the offence is the dishonest conduct. Okay, so the court in Hayes have made this very clear. It's the dishonesty that matters. So if you do something dishonest, right, you use something to obtain a benefit or an advantage, even if, and this is where Hayes changed the law, even if that benefit or advantage was something you were entitled to, if you were dishonest in the way that you tried to get it, you can be guilty under section 228. Okay, so as I said, the essence of the offence is really the dishonesty aspect of it. So it's a fairly weighty sort of a section. Essentially what it covers is sort of two aspects where you dishonestly and without claim of right take or obtain any document, or you dishonestly and without claim of right use or attempt to use any document, and you do so with an intention to obtain any additional value thing, then you are looking at being covered by section 228. So your elements are the item is a document. Now, a document is an incredibly wide definition. It basically covers anything that has writing on it. So you're looking at a credit card, online tickets, paintings, tickets to get into concerts. The defendant must then take, obtain, use or attempt to use it. And they must intend to obtain some kind of advantage, right? So attempt to obtain some kind of property, service, okay, something that is of value, and they must do so dishonestly and without claim of right. And remember that even if you are entitled to the thing that you actually acquire, you can still be guilty under Section 228. You don't even have to actually have achieved the benefit that you were trying to get. It's enough that you tried. Okay, so it's a very wide section. It's often used where someone tries to use a credit card to get an advantage, where they try to use a ticket of some kind to get in somewhere, where you're using documentation to try and get some kind of benefit, ACC benefit, ACC payout, housing benefit, all those sorts of things. This is where this section is most often used. So even if it turned out that you were entitled to a benefit that you dishonestly tried to get, you would be guilty under Section 228, provided everything else is satisfied. Okay. 240, obtaining by deception or causing loss by deception. Should we take the break now? Yeah, you're like, yes, please. Take the break now, then we'll get into the meatier obtaining by deception. I know this is not the most exciting. Next week we do parties. That's much better.
Jan said that because she wanted to sit alone, but I'm like...
Okay, can we get underway? Can I just say, as a result of a question asked of me in the break, obviously I haven't done a very good job of explaining this, but one of the reasons why I'm trying to give you some of these little ancillary sort of offences like 228 is because when we teach property like we're only giving you a couple of offences, it becomes quite difficult to understand how the offence works when you can't see all the other offences that are built into property offences, right? So if you can see that, well, this property offence only applies here, and the reason why it doesn't work in other situations is because I've got another offence that comes in and then fits into that little hole there, and then there's another offence that might come in and fill that gap there. So this is this whole idea that we keep adding to our law with these different offences to fill these different gaps where the law doesn't work well, like Section 219, as you've discovered, doesn't work that well for many things, and so we keep adding all these other offences. So I'm trying to give you sort of this idea of some of the offences that come in and fill the gaps to help you understand the ones that we are covering. Right? Hopefully that helps. By the looks of your faces, not really. Okay, so we're looking at obtaining by deception or causing loss by deception. Now this is, we'll cover a situation where, for those of you that may have already done your tutorial this week, we'll cover some of the situations where someone has taken possession of property with consent but has been deceptive in the way that they've obtained it, or that they've gained some kind of advantage or some kind of benefit that doesn't fall within the definition of property. And the punishment for this is built around the value of the advantage gained or the loss caused. Okay, so for our 228, the punishment is 7 years, so quite hefty. And I think, well, theft in a special relationship is, have I remembered, I think it's 7 years as well. I haven't got it there, but yeah, so these, we're back to sort of looking at what is the value of the property and as opposed to just a maximum sentence. When we're looking at the way in which the basic structure of the offence itself, we're looking at Section 240, and it covers a situation where you've got someone who carries out some kind of deception, and they do that without claim of right, and they obtain some kind of value of something, so obtain ownership or possession or control over something of value, or in incurring some debt or liability they get credit, or they induce someone or cause someone to do something with a document that causes them to get some kind of benefit, or they cause loss to another person. Okay, so it's quite a broad section, so essentially you're obtaining something or you're causing loss of something. Right, so our case of Morley, which is the main case dealing with 240, has made it very clear that we've got two ways in which this offence operates. One is obtaining, and one is obtaining by deception, and one is causing loss by deception. Okay, so they're two separate things. And because of the word by, so obtaining by deception and causing loss by deception, there's got to be a causal link between the deception and what is obtained and the deception and what is lost. Okay, so that's inherent in the word by. Now, actus reus requirements or elements are: the defendant must engage in some deception. Right, we'll have a look at what that means in a minute. And that deception, therefore, must cause the defendant to obtain ownership, possession or control of something of value, or they must obtain credit, that's accompanied by a debt and liability, or induce someone to perform some kind of physical act in relation to a document. Don't see that one used very often, I won't cover it much at all, or they cause loss to another person. Okay, so you'll always have to show that you've got the deception and that it caused one of these things. In terms of your mens rea requirements, and this must happen at the same time as the deception, so you've always got to have concurrence here. There's got to be an intention that the person should be deceived. Okay, it's got to be your purpose to actually deceive the person. You've got to have acted without claim of right. And if the deception relied upon, and we're going to have a look at that definition more thoroughly in a minute, as a false representation, you're going to find out what that is, then the person who makes the representation must either know it's false or be reckless as to whether it is false in a material aspect. Now, deception has quite a wide meaning, and it's defined in section 240, subsection 2. So you've got three different types of deception. You've got a false representation, and that can be oral, documentary, or by conduct. And as I said, where the representation intends to deceive someone, you've got to know it's false or be reckless as to its falsity. You've got to have, where you have an omission, you've got to have a duty to disclose. And then the final one is a fraudulent sort of trick, right, which is a bit of a catch-all. So the main emphasis is going to be looking at false representations, because that's where you tend to see most of the case law focusing on. Okay, so as I said, you've got three separate types of deception in essence. False representation, omission, and a fraudulent device, trick, or stratagem. Excuse me. Now, when we look at a false representation, as you can see from the words of the section, it can be oral, documentary, or by conduct. So in other words, you can speak it, it can be on the written page, or you can imply it by your behaviour. And it's got to be materially false. Okay, it's got to be false in some way that makes a material difference. And when we talk about what a material difference is, or in a material particular, the court in O'Brien said it's got to be a material particular as something that has made or could make a difference to the victim's decision. And in Carlos, the court said that the prosecution must actually identify the representation relied upon. So where you've got more than one representation that, as a prosecutor, you're relying upon, the jury have to agree that at least one of those representations was false. Okay, you can't just sort of throw a whole lot in there and hope that one of them is going to land, sort of in a bundle, right? There's actually got to be a decision by the jury that one of those things is actually false for there to be a false representation. It can be false in many ways. But unless it's false in a material way, it won't be classed as a deception. Okay, so you're not going to be convicted of deception if you're you give some sort of false representation as to something which is a small thing, which is not material, doesn't have any kind of make any kind of material difference to the person who's making the decision. But it must relate to a statement of existing fact rather than a statement of future intention. Okay, so when we say existing fact, what we mean is a present or past fact. Okay, so if I'm making some sort of statement about a future intention or expectation, that's not going to suffice. Now, obviously, where you've got a written or oral statement, it's usually quite simple to work out whether or not you've got a representation and then work out whether or not that's false. But it becomes a little bit more difficult because it includes implied conduct. Now, in the Morley case, they gave quite a few examples of situations where they said the conduct of the defendant had implied a representation. So examples they gave, and they are quite old, well, old from your point of view, not old by mine, where you present a credit card, you are presenting to the retailer that the credit card will be honoured on their presentation of the voucher to the bank, that when you call up a taxi, you are representing that you will in fact pay and are able to pay the taxi fare. When entering a restaurant, you in fact are giving an implied representation that you have the ability to pay for the food you order. Same thing when you go and register at a hotel as a guest. Okay, now, these things go back some years, and it's interesting that you think about how that's changed. More often than not now, those implied representations, we don't really allow those things now because everyone expects payment up front. You go into a bar, you go into a restaurant, you put your credit card up, right? Taxis, I mean, everyone uses Uber nowadays, it's all prepaid. Okay, so but it does show an indication of what is an implied representation, and when they looked at this in Morley, which involved a situation where a person had got himself into a contract where he had contracted to buy some houses that he couldn't then settle on, they had to consider whether he had given an implied representation that he intended to settle. Right, so they relied upon these old cases. And they held that, in fact, in entering into an unconditional contract to purchase land, to purchase these houses, he had given an implied representation that the facts existing at the time of entering the contract, that on the settlement date he would, in fact, settle and have the funds to settle, and that he intended to settle. Okay, now you've got to remember that what we're talking about here is, we're not talking about someone who ends up not being able to settle on a house and getting sued. We're talking about someone who is being charged with theft, okay, or charged with obtaining by deception. All right, so this is a criminal offence as opposed to a civil debt situation, right? So they looked at not just the words itself, but also the conduct carried out by him, and the fact also in particular that he'd entered into this unconditional contract. And it can also, as happened in the case of Morley, it can be passed on indirectly through a third party, which is what happened in that case. Right? So it doesn't even have to be implied conduct by the defendant themselves. Now, what about silence? Okay, what happens in the instance of silence? Can you actually be held to have a false representation where you are silent? And you may remember our Dron Jack case, where the guy went up to the counter with a stereo and it had 2 stickers on it, and the person behind the counter looked at the lower amount, and that was what he charged him, and he left the shop with the stereo. Now, he couldn't be charged with theft. Anyone remember why? You're like, oh, I'm not even listening to you. What's she asking us? Why couldn't Dron Jack be charged with theft when he left the shop with the stereo? I can see some of you flipping through your notes. What was that, Anna? Well, when he took it up to the counter and he handed over the stereo and the guy charged him the lesser amount and he gave him the stereo, was that given with consent? So what does that mean when he left the shop? I can't hear. Be brave, people, be brave. I know I've just woken you up from a slumber. If you get possession with consent, what does it mean? Emily? Sorry? No taking, right? Because you've got consent, which means you get ownership. Lovely, thank you. Beautiful. Okay, you've got ownership, right? He's got ownership, he can't use a deal. And the consent is given voluntarily, right? So no theft. But in this case, it fell into 240, right? Because by knowing that the person had charged the lesser amount, right, and saying nothing as he did, right, his failure to inform him of his taking the lesser amount meant that he had created this false representation by his silence. All right, so that was considered to be a deception. What about half-truths? What if you just sort of only tell half the story? Now, in Lang and Police, this guy went around and he was collecting donations. And he said he was collecting donations for the relief of poverty. Right, he was, in fact, himself impoverished. You can see where this is going. And he used the money for himself. Right? Now, the representation, the implied representation in going around and collecting money for poverty is that you are going to pass that money on to some charity. Right? So the court said that his half-truth of collecting money for poverty, for impoverished people, that half-truth and then the failure to add the additional thing that, in fact, I'm not going to give it to someone else, meant that it was a false representation. Right? This is not a New Zealand case, but there was also a case of silence in the course of dealing where this guy had done, this is in the Silverman case, he'd done a lot of work over a period of years for this person, and he'd built up this sense of trust. He was aware that this person trusted him and that he thought he was giving him a good deal by doing this wiring on his house, and he was aware that this person had this impression. Right? In fact, he was creaming him, right? He was absolutely overcharging him. Right? And so with the fact that he carried on in the course of conduct meant that that was a false implied representation. Okay. Actually, sorry, before I cover that, I'm just going to cover sales talk. So if the prosecution alleges a representation is false, it must show that it's actually false and that it's capable of being false. Okay, so if I give an exaggerated or descriptive opinion of something, that may not amount to false representation because it may not be possible to actually assess that it is false or not. Right? So if I give some kind of opinion on a normative quality, something is beautiful, it's excellent, it's good, it's amazing, this lecture is so interesting. Is anyone going to call me on that? That's false. Right? It may be impossible to assess. Right? So if I say, my car is amazing, I love my car, it's incredible, it's an incredible car. Right? That's my opinion. Okay, you can't show that that is false. But if, and someone comes to look at my car to buy it, not sure you would, it's a 1997 Toyota Caldina that still bears the marks of my children scratching it with pine cones and has yeet scratched into the roof. And I said, it's an amazing car, I love my car, to someone who was looking to buy it. Now, if somebody could say, oh, actually, yesterday she said, it's a piece of crap, I can't wait to get rid of it, then that would show that when I said, I love my car, it's an amazing car, it's a beautiful car, that I knew it was false. All right, so that might be enough to then show that I knew it was false. In fact, I was making a false representation. Okay, but you've got to look out for these opinions, these puffery, this sales talk. Right? It's not necessarily going to be a false representation. Briefly looking at omissions. Now, an omission will only create a deception if you have a duty to disclose. Somehow I don't know if I can actually amend this. Sorry about that. Somewhere I've put in there a return. So if you've got a fiduciary relationship, that might give rise to an obligation to make disclosure. Now, in the case of Chen, this person had acted, he was a solicitor who was acting for a bank, and he got himself in some strife because the bank gave a loan and he knew that the documentation that had been relied upon by the bank to give the loan was false, right? And he said nothing. And he knew this because somehow he was involved, had some personal involvement in the transaction, but he also acted for a client, and that was how he'd become privy to that information. Now, this would have caused huge ethical issues for him, but that's a problem for another day. Okay, and by saying nothing to his client, that was the bank, okay, he had a duty to disclose under his fiduciary relationship to the client. He didn't, and therefore it was an omission and a deception. Fraudulent devices, tricks, or stratagems. So these are just things that, it's a little bit of a catch-all, it's not used very often. In O'Brien, we'll look at this one in a minute for another area, but this was a case where they applied for an application for a gambling licence and they left off the application the fact that this guy was still involved in the company because he's a bit of a dodgy dude. Okay, so that in and of itself was a false representation. We could even argue it was an omission. But where it fell into being a device, trick or stratagem was they had this, after they got the actual licence, they had this strategy to hide the fact that he was still involved. And that hiding his involvement, his continued involvement in the company, was considered to be deception under Section 240, subsection 2C, right? Because it was an ongoing strategy. Now, as I said at the beginning, the deception must be an operative and material inducement, and that it must cause what's obtained or what's lost. Okay, you've got to have a causal relationship, and this is essential. Okay, this is absolutely essential to this offence. This is what Morley has described as the gist of the whole offence. Okay, so to put it the other way, the obtaining of the benefit or the advantage or the loss must occur as a consequence of the deception. Okay, so we're back to causation. Right, remember causation from semester 1? Yes, yes, that's right, yes. So when they say that we do actually build on these things we learn in semester 1, they actually meant it. Right? So you're still looking at all your causation principles. So the deception must induce the victim to hand over the goods or give the credit or incur the loss. But it need not be the sole cause, so long as it plays a material part. Right, so it must be operative, that term should ring a bell for you, right, and a material inducement. So turning back to our O'Brien case with the gambling licence. So in that case, they had a bit of a suspicion that this wasn't quite right, that the application wasn't quite right, but they couldn't really quite find the grounds to decline it. So what they did was actually granted a shorter licence than they ordinarily would, so they could investigate. And the court said this suspicion did not negate the link between the deception and the obtaining. Okay, even if they granted a shorter licence so they could investigate, there was still a causative link. It still played a material part in then obtaining the licence. However, if the victim is not deceived by the deception, okay, they're unaffected by the deception, then it will not provide a causative link. In the case of Hunter and Police, now this guy gave a false name to a furniture removal company because he didn't want to pay. Right, so we thought if he gave a false name, that would mean that they wouldn't be able to pursue him. And they provided the service to him. They removed his furniture for him. And the court said that the deception wasn't causative of the obtaining of the service because it made no difference whatsoever. Right? If he'd given his real name, it wouldn't have mattered. The fact that he gave a false name made no difference. It wasn't that they did any credit check to ascertain if he could pay. Right, so it made no difference whatsoever that, in fact, he had given a false representation. Right, but for the false representation, so anyone remember the factual causation test, Hawkins? Your faces. Okay, it made no difference, right? Can't say but for the but for the deception, they wouldn't have provided the service, they would have done it anyway. What about an automated machine? Can you deceive an ATM? What do you think? I'm seeing some nods. Do you reckon? Yep. Now, what does an ATM machine do? It's pre-programmed that when you put your card in, you press in the numbers, the money will come out. Okay, so how do you deceive it? How do you do a false representation? If you're going to get on a bus and you use somebody else's card? Have you deceived the bus? How can you cause the obtaining, if there's no causal link between what you've done and the provision of the benefit? It would have happened anyway. Okay, the fact that you have provided a false representation makes no difference. Okay, it's pre-programmed to do whatever it does. Okay, so you can't actually deceive an automated machine. But the courts have said that where there is some kind of human intervention, right, we don't say that the outcome is predetermined. Okay, so in the case of Queen and Dew, the court said that where they had provided these I think it was mortgages, right, and even though they had used machines to determine whether or not the mortgage should be provided, there was still some human intervention, and as a result, there could be a causal link between the false representation and what is obtained. Right, but you can't, something that is completely automated, you can't actually deceive it. Right? Now, as I said at the beginning, we've got two types of offences, right? Morley has confirmed this. So you've got the obtaining of something under sections 2401 A through to C, which is your obtaining of property or credit or the execution of some document, and then you've got this other type of offence which is causing loss. Okay, so when you're looking at the first three, or the first one, which includes those first three, which is obtaining credit or the execution of a document, you've got to require proof of a defined outcome. Okay, you remember in 228, you don't have to prove an outcome. You don't have to prove a benefit was obtained. If you're going to use 240, you've got to actually show some benefit is obtained. All right? Now, obtained has the same meaning as 217, under 217, which includes retained. And you should point to which subsection you are relying upon. Okay, so the prosecution's required to actually say which subsection they're relying upon and the outcome that is actually obtained. When you're looking at loss by deception, which is what they were looking at in Morley, the nature of the loss is not defined in the section. It's not so clear. So when you're looking at obtaining some kind of ownership, possession or control over something, then you've got property, very wide. This is where we fill the gap created by Wilkinson. Now you remember in Wilkinson they had the money that was transferred, and I put that in inverted commas. Okay, but all that was, in Wilkinson they said all that happened was that one thing in action was extinguished and another one created for the person who provided the money, so to speak, and another one was created with respect to the defendant. Okay, so the victim's thing in action went down, the defendant's thing in action went up. Okay, they had the ability to sue for, go to the bank and demand more money. The victim lost the ability to go to the bank and ask for as much money. So there's a loss, all right, which means that that is now caught by section 240. Okay, so this is where it fills the gap created by theft because of our problem with financial online transactions. 240 can fill that gap because as long as you've got a loss, and also you don't have to show that even at the time of the deception that the property was even in the hands of the victim or in the control of the victim or that it even existed. Okay, so at the time of the deception in Wilkinson, the thing in action didn't even exist. Okay, and that wasn't a problem under 240. In Lee and Queen, they said it was a very broad interpretation of benefit. And in that case, this person had a certificate endorsing they had a tertiary achievement. They did nothing with it, right? But they said that that was a benefit in and of itself. It was a good. It provided an advantage, irrespective of whether or not they had tried to get a job by using it. Okay? So it's a very broad interpretation. When looking at credit, you might even be lucky, I might even finish early today. That perked you up. When looking at a credit, you've got to have an accompanying debt or liability. Okay, so you enter into some form of debt and liability, and as a result of that, you obtain a credit. So credit can be access to money, can be services, or items worth money. So the court have said it's got to be fresh credit because of the word obtain. Right, so under 228, if you've got credit and then you extend that credit, or you've got debt or liability and you extend that to get more credit, 240 won't capture that because you haven't obtained it, whereas 228 might. So if you're obtaining credit, it's got to be fresh credit. But it doesn't even necessarily have to be for you. So under Chen, they said it doesn't even have to be for the benefit or provided to the defendant. It's sufficient if it's created or credited, for a third person. Now, as I said earlier, 240 subsection 1c is very rarely ever used. This is where you might cause someone to alter, say, a document to derive a pecuniary advantage. Usually it will fall under the other subsections, which is why it's not used very often. So remember under 2A through to C, you have to show the outcome. If you define what the outcome is that's been achieved, under 2D, you're looking at loss by deception, and it's not actually defined. And in Morley, this caused some problems because they were having to work out what actually is a loss that is covered by the section. So as I said, in that case, the person had entered into this contract, this unconditional contract to buy these houses, and he couldn't fulfil it. And the court had to decide what sort of losses could then fall under Section 240, what losses were caused by the deception. So the people had on-sold the properties when he couldn't actually fulfil the contract. They on-sold them, but they sold them for a lesser amount. Right, so they were claiming the the difference, right? And the court said that that was loss of a bargain or an expectation loss, and that is not covered by Section 240. It must be a direct loss. Okay, so had they incurred some kind of penalties, or had they incurred some kind of expenditure as a result of the deception, that would have been covered. But the money lost in selling the property for something less was not covered by Section 240. Now, obviously, you could sue for the amount civilly, but the loss itself didn't fall into Section 240. Under the case of Kai, they said even a temporary loss will be sufficient. And this was a situation where a person got hold of some passwords and they transferred, I think it was $80,000 into an account out of the victim's account, and the bank got suspicious about this. So they froze the account and they froze the transaction and they reversed it. Right? And they said, even though it was a temporary loss, that is still a loss for the purposes of Section 240. Because during that period of time that money was out of the account, the victim was unable to access that money or go to the bank and demand that money. Okay, so even though it was a temporary loss, it did fall within a loss under Section 240. Okay, we're on the home stretch. Mens rea elements for 240. Now, you've got to have an intention to deceive. Okay, you've got to have an intention that the other person should be deceived. So you've got this causal link as an actus reus, and you've got to have an intention that the person should be deceived by your deception. You have to have no claim of right, you know what that means. And if it is a false representation, then you must know that it's false or be reckless as to whether it's false in some material aspect. Now, an honest or even unreasonable belief that the representation is true will therefore negate the deception. And what Morley has said in addition to that is that there's no need to prove that the defendant had an intention to cause the outcome. Okay, so even though you have to intend to deceive, you don't have to intend to cause the outcome. The court in Morley made it clear that that is an actus reus requirement. The outcome is an actus reus requirement. There's no additional requirement under the section to show an intention to actually cause that particular outcome. However, there will be circumstances where the loss is unexpected and not reasonably foreseen. Right? So the court thought that that was unfair. And therefore, at 54 of the judgment, said the deception must be objectively viewed as to have been likely to cause at least some loss at a more than trivial level. Does that sound familiar to anyone? Right. Anyone remember the case where that might come from? Yeah? Yeah, Quinn and Lee. Okay, so you're starting to see some of your, surprisingly, I'm sure for some of you, starting to see some of the stuff that you learned in semester one really starting to feed through all these offences, even in property. Okay, so they basically said that you've got to then have loss that is foreseeable objectively foreseeable, some loss at a more than trivial level. Okay? It's not fair for someone to be caught by a loss that is unexpected and not reasonably foreseen. Right? But remembering that you also don't have to show an intention to cause that particular outcome, just an intention to deceive. Right, that's as much as I'm going to say about obtaining by deception. Last one, burglary. Quickly, it's a very simple offence. Now, there's two ways of committing burglary. You enter a building without authority to commit an offence, or you remain in a property or building without authority to commit an offence. Now, when you have a client who's looking at a charge of burglary, or sometimes where they've been convicted of burglary and you're looking at appearing for them on a sentence, quite often, back in the days when you used to get a printout of their previous convictions, sometimes you'd go down to court, depending on when you were appointed to act, and you'd go up to the police prosecutor and say, oh, look, I haven't had disclosure yet. Can I have a look at my client's previous? And they would hand you this printout from the computer, and it would literally be, right, and it would be burglary after burglary after burglary. So when you are looking at sentencing for burglary, it's one of those instances where the way in which we sentence on burglary charges is slightly different to others, because where you've got these cumulative charges, cumulative convictions, the previous convictions are dealt with in a slightly different way. So burglary is one of those ones where all you have to do is really show it as entry. Now, entry can be proven very, very simply. It's pretty much any part of the defendant's body comes within the building. So if a window is open and a person puts their hand through the window onto the windowsill to haul themselves up, that is entry. If a person uses a crowbar to break a window and the crowbar goes through the window through into the building or the property, that is entry. Okay, so entry is very simple to prove. Right, it is any part of the defendant's body within the building, or anything that is usually being used by the person. Without authority is usually quite simple to prove, but where a person is claiming they had authority, you're generally looking at what is the authority asserted, what is the extent of that authority, and have they exceeded it. Okay, it's not normally too difficult to prove. And in terms of an imprisonable offence, your best evidence is obviously the fact that the person actually committed an offence, although they need not. All you have to show is that they formed an intention to do so. Quite often people get charged with carrying an instrument for the purposes of carrying out an offence. Things like crowbars, screwdrivers, are not usually things that you carry around in a bag in the middle of the night. Right, just something to be aware of. So if someone is found in a house with that sort of item, even if they haven't taken anything yet, that is pretty clear evidence of an intention. And that is all I need to say about that. So that you'll be relieved to know is the end of property. And next week we start on our final topic, of parties. Party liability is about how do we scoop a whole lot of people in that have done different things when offending. And it's the last topic. Thank you for listening.
It's good. It's quite warm, isn't it?
Yeah, and also this thing here, well, it's off now, but it generates quite a lot of heat.
Thank you.
See you. It is incredible. I'm just going to log out since I'm going to log in.
Makes me feel better.
that should.
Yeah, because they've already assigned, but they've allocated the.
There you go, I'm out. Now that was here prior to, so I don't.
Oh, yeah, cool, thank you. I was trying to find my USB. There it is. Amongst my messy bag. Enjoy the rest of your evening. It is so beautiful out there.
Is it really?
Yeah, it's like sunny and blue sky.
I'm going to be to work, so it makes no difference to me.
Oh. See you later.